All right. Good afternoon, everyone. Thank you for joining us both in person and by Zoom. My name is Maisha Carey. I'm a criminal defense lawyer and I'm based in the East region of Ontario. But today we're live from the New Toronto Courthouse at 10 Armory, and we have three distinguished guests that you all know. Defense lawyer Emma Rhodes and Justice Brock Jones, who was a Crown and who will be filling in for the Crown part today as well, giving us some kind of advice on the Crown side, and Dr. Skilling, who will also give us some excellent feedback on youth criminal justice system. So this is an hour and a half. It is recorded, and we will be posting it to the WiCCD listserv, and the participants will be receiving a copy of it. I won't be taking too much time, just to say, and that it is eligible for 1 hour and 20 minutes of substantive CPD. We will start by a brief presentation on the principles of sentencing in youth criminal justice with Justice Jones, but after that we will be having a discussion on crime as we are seeing it right now in the youth system.
Meet again tonight.
I will let Justice Jones start by his presentation. He does have slides that we provided to our attendees in advance. If you haven't received them, just get in touch with the WiCCD team and we will send them to you.
Thanks everyone for joining us here. We know we're off to a great start. Technology is actually working in this new building, and if you're here regularly, you should never assume that. I really do appreciate everyone joining. We're going to talk about a lot today. Most we're going to focus on violent crime in youth and what's different in youth court opposed to adult court, how you should approach these matters when representing a young person or as a Crown when prosecuting these cases. And hopefully we're going to touch on some of the very important differences, unique provisions of the Youth Criminal Justice Act. We don't have any analog in the criminal code for adults. I hope you did get the slideshow that was distributed to people in advance of the presentation today. I don't want to spend too much time on it, but the content is in there for people. I hope it's of some assistance. But just to ground everyone and to start, especially if you haven't been in youth court before, or you're not familiar with the Youth Criminal Justice Act, I think to begin, it would be helpful just to go over some sort of foundational principles. And I'm going to try to highlight bit by bit why the Youth Criminal Justice Act was enacted by Parliament so many years ago and how it's different from the Adult Criminal Code, again, in these very key areas. So I'm going to try not to share my screen, and I think it's all going to go well here. Okay. We are on fire. Okay. Literal fire, though. Okay, hold on. Just adapt.
That looks good.
No, it's not good. There we go. That's much better. Okay. So what I want to start with is just this. I appreciate that criminal law is notoriously complex already. It's hard to keep up with everything. And if you add to the criminal code, the Youth Criminal Justice Act, it can feel very daunting. And as I'll explain, there are important, very important key differences between the Youth Criminal Justice Act and the criminal code. But I encourage you to take on this type of work and to get involved with it if possible. It's also extremely rewarding. There are far more happy stories that come out of youth court, I would say, overall, and come out, unfortunately, of adult court, where some people have trouble not coming back. In youth court, the stories are almost overwhelmingly positive, and most youth do not engage with the criminal justice system once they become adults. But the sentencing provisions in particular are distinct in very important ways, and it's important to keep that in mind, because if you come into youth court with the wrong perspective, or you just think, you know, nothing's really that different, maybe the penalties are a bit lighter and everyone's a bit shorter, you're going to make mistakes, because there's a lot more to it than just that. And help is always available. Okay? I'm sure you have colleagues and members of the bar in your local communities that are very experienced and helpful. You can always reach out to. In an act of shameless self-promotion, Emma and I have just authored the 3rd edition of our book, which I will give away to someone here who came in person at my sole moral discretion. But it's also available online for even for anyone else. We've done our very best to keep it current, but also topical in areas that I think you're going to experience regularly in youth court, not just with substantive law, but with hopefully practical tips about how to approach these problems. Okay, to start off, keep in mind the following. The Youth Criminal Justice Act has been in force now for over 20 years, and it replaced the Young Offenders Act. It didn't just amend it.
So let me stop there.
Please.
I always interrupt.
Please,
Please.
go.
Oh, God. Okay, so yes, YCJA replaced Young Offenders Act. So right there is the big light bulb, stop saying YOs. Crown, please stop having, even when we're signing up or even in disclosure, everything's always referenced to YOs. And I see defense as well signing up on the set date list or the case management list and saying they're there for a YO. You should not be saying that unless your client was charged before April 1st, 2003. Is YP or do not write down YO, do not say YO, do not even think YO unless you are dealing with somebody that was charged before 2003. Because as soon as you say that, you're saying that you don't know the legislation. So that's like the first indication is when you say YO. So YP, youth, that's the terminology that you should be using.
I'll joke aside, it's actually a really good point. Because if you come into youth court and I start hearing language like that, it will start to give you some concerns that perhaps you may not be as up to speed on the legislation as you should be, given you're referring to the wrong legislation. But I know the culture is hard to shift. Why do we have this legislation? Okay, under the Young Offenders Act, believe it or not, Canada had the highest per capita rate of incarceration for youth in the developed world. And this wasn't close. If you were to break down Canada, in fact, province by province, and compare it to the United States on a state by state level, the jurisdictions with the highest rates of incarceration weren't, Texas or Louisiana or Florida, what you might suspect. They were our Western provinces, whose rates of incarceration for Indigenous youth in particular were just shockingly high, by an order of about 20% higher than the average American state. And it was primarily for non-violent offenses as well. So there was an acceptance at the time that something had to change. So it was very costly, it wasn't terribly humane, and it also wasn't very effective. So the Youth Criminal Justice Act was enacted with one of its primary, maybe its core, to reduce the rate of incarceration among young persons across the board. And an early case from the Supreme Court of Canada, you'll see I put on there CD and CDK. Supreme Court was given an opportunity to speak about this legislation. And right there, the Youth Criminal Justice Act is intended to reduce the unacceptably high level of youth incarceration that had been occurring under the Young Offenders Act. And the preamble to the legislation makes it clear that custody should be reserved only in the most serious interventions for the most serious crimes, in order to reduce that over-reliance on incarceration. I encourage you when you come into youth court to come in with a different mindset. The philosophy behind the legislation is very different than the criminal code. There's a great line, I know that many of you have had to sit through my presentations before, heard me say many a time, but children cannot simply be viewed as miniature adults. That comes from Justice Sotomayor in a very interesting American case. But that's the philosophy you have to learn to embrace. As well, it's very important that we engage parents, families, and other caregivers as much as is possible. And
But I'd say as an aside, subject to the instructions of your client.
that's why you're here.
Yes.
Thank you. But as Emma will tell us about a lot more later too, about half of the youth who appear before you in youth court, or the youth you're prosecuting, okay, have had past or ongoing experience with the local child welfare system. Sometimes they're referred to as crossover youth, at least here in Ontario. And so many youth who come before the youth justice courts, the overwhelming majority, come from difficult backgrounds. They've had life experience many of us can't fathom having had at that point in their very young lives. That's also something that should always be considered when you're assessing youth cases. And as Dr. Skilling will explain to us as well, I'm sure, there are very important developmental milestones that go on in all of our development well past the age of 18. So it's not just that young people have less life experience, of course, by definition. Their brains continue to develop well into the mid-20s or so. Is that not correct? Especially areas that deal with judgment and dealing with peer pressure and risk assessment, the sorts of things that factor in sometimes to how we assess culpability in criminal law. Okay. Very briefly, before we turn it back to the discussion, remember some of the fundamental principles that are in the statute. The goal is to hold young persons accountable through measures that are proportionate to the seriousness of the offense and the degree of responsibility of that young person. And very importantly, the criminal justice system for young persons must be separate from that of adults and must be based on the principle of diminished moral culpability. That principle was established by the Supreme Court of Canada in a 2008 case called DB. It's a principle of fundamental justice under the Charter. It was since enacted into the statute as well in some amendments about 10 years ago. But that is the starting point. Every young person comes into youth criminal court with this principle of diminished moral culpability attached to them. And it is only rebutted in very rare circumstances, typically where the Crown seeks an adult sentence. We'll talk about it a little bit later today, but it's very, very uncommon. Do you want to add anything at this stage?
So rehabilitation and reintegration, if you get anything, that should be, you should be saying that all the time when you're doing sentencing for a young person. I went through and counted how many times that is together in the act. I counted at least 5. So it's in the principle, the preamble, it's in the sentencing principles, it's later on in sentencing. So, and all the other one, fair and proportionate accountability, enhanced procedural protection, timely intervention, not mentioned as much. But rehabilitation and reintegration is mentioned at least 5 times. So those are the buzzwords, if you will, of the WiCCD. So if you're giving submissions and you're not, you should be shoving those terms in before anything else.
Something else I would emphasize to right now is don't forget the importance of timely intervention. I think many of us almost become dull to the fact that many cases drag in criminal court for a considerable period of time. 6 months in the life of a youth, a year, more than a year. This is an eternity to a young person, right? Suddenly they're not in grade 8 anymore, grade 9 or grade 10. It's like a lifetime ago that whatever happened actually happened. The statute places an emphasis on attempting to deal with new cases as quickly as possible so that there's a nexus between offending behavior and consequence, but also it's more meaningful to that young person that they do something quickly, assuming that there's some acceptance of responsibility. And failure to adhere to that principle of timely intervention has been recognized by the Supreme Court in a case on how Jordan principles are applied in youth court. It's something to consider. And should you run across a judge who maybe believes in Jordan principles, that could be an issue in youth court. So please keep that in mind as well, whatever side of the fence you might be on.
And just in terms of timely intervention, I would say to Crowns, it's easy to say, oh, this young person, this was a year ago. And we think about a year in our own terms, but when you're a Crown and you are making these decisions, to actually think about what time means for a young person. And how I say it is, remember when you were in grade 6 or grade 7, and it was the first day of school, Christmas holidays or the winter holidays were considered a lifetime away. Now as adults, we are thinking about Christmas holidays in September because we know it's going to happen in a minute. But for a young person, it seems like they're going to happen, like that's not even on their radar. And so just remembering that time when you were like going into school, the first day of school, was that even on your radar? Of course not. And it really goes to show and to remind you how different the concept of time is for young people.
So we're going to talk, yes, go ahead.
Can I just confirm the Jordan, that ceiling is the same?
Yes.
For you, exactly.
So the Jordan ceiling is the same. That argument was presented to the Supreme Court and they couldn't change the ceiling. But there is a however, and there was sort of unanimous acceptance, even in decisions authored by Justice Moldaver, that it is important to accelerate youth cases to the extent possible. And it will be much easier to bring Jordan applications under this ceiling for a young person than it would be for an adult. So I encourage you to read that decision. Sorry, the initials are escaping me at the moment, but it was released only in the last few years. And I think it makes a very clear point that there's a duty on all of us to ensure it's in the book. It's definitely in the book. So keep that in mind. Okay, but today we're going to focus more on sentencing. That was the purpose of what we really want to do with the time we have today. So let me just set the stage for what's different about sentencing for youth as quickly as I can. It's so different. In fact, I couldn't do it justice in just a few slides, but at least we'll hit the highlights here to give everyone a starting point. The first thing to remember is this. The Youth Criminal Justice Act, remember, was intended to reduce the use of custody for youth. So the statute actually sets up barriers, or gateways, as they're sometimes called, to the imposition of custodial sentences. There's an emphasis, overwhelming emphasis, on community-based dispositions, because the concept of putting a young person in custody, right, is a very, very serious one. I would say it weighs much more heavily on me potentially than it would be to incarcerate an adult, though I felt otherwise that was required in an adult case. If custody is imposed, there are different levels of custody that the court can choose from. There's secure custody, which is what I suppose most people would think of as, quote, youth jail, although it's not exactly that. There's open custody, which is a little bit more akin to being sort of a group home setting. And then there's also, of course, deferred custody, which is like house arrest or a conditional sentence for adults. Youth also have access to sentence reviews. And then while it is possible to obtain an adult sentence for young people in very rare circumstances, there is a very difficult test to meet. And it is brought by the Crown. I would say those applications, in my experience, in my prior career, extremely rare.
But increasing.
But increasing, is that correct? Well, we'll talk about that.
Dr. Skilling can talk about that.
There were some tough grounds in the room, I guess we'll find out. Okay, what's the fundamental purpose and principle of section 38? To hold a young person accountable for an offense through the imposition of just sanctions that have meaningful consequences for the young person, and as Emma said, and that promote his or her long-term rehabilitation and reintegration into society. So those are the buzzwords there I put in sort of the highlighted colors. Please keep in mind, certain things do not exist in youth court. General deterrence is not a sentencing principle in youth court. Woe to the Crown who comes into youth court and asks me to emphasize general deterrence in sentencing a young person. Oh, you won't want to read that judgment, all right? And specific deterrence and denunciation are optional sentencing principles. They don't necessarily apply, they will in certain adult cases where the case law might say they should just commonly be applied. What is the gateway I was referring to? Okay, there are only 4 ways that a young person can be sentenced to a custodial sentence. The most common one overwhelmingly is the young person has committed a quote violent offense. We'll talk what that actually means in youth court in a moment.
And so, and I'll,
Go ahead.
because I always interrupt. So violent offense is defined in the beginning of the act. Violent offense should not be confused with a serious offense or a serious violent offense. So there's violent offense, serious violent offense. All 3 are distinct, all 3 are defined, they all mean different things.
Yes. I give you the book, we wrote it with me, so that's not fair. All right. B and C talk about failing to comply with non-custodial sentences. If you have a young person who keeps coming back, I suppose, that they give it a chance to try something non-custodial and hasn't worked, that might be a gateway. When I was a Crown, I don't recall ever relying upon those sections, actually. I don't know if it's being argued now. Because normally the offense has to be serious enough to justify custody in and of itself, which we typically call it for something violent, or the exceptional cases where the young person has committed an indictable offense and the aggravating circumstances of the offense are such that the imposition of a non-custodial sentence would simply be inconsistent with purposes and principles set out in the statute. Now, exceptional cases originally, they were interpreted by the Court of Appeal in this province to really be exceptional. The landmark case involves a 14-year-old girl who helped cut up and hide a body after a murder happened, although she was not a party to the murder itself. That's pretty exceptional. Since then, of course, that has been applied to certain other types of offenses, and probably the most commonly argued one, at least in the GTA, might be firearm possession. Young person caught with a loaded handgun, for example, adult might be looking at an upper reformatory to low penitentiary sentence. Suddenly in youth court, it's a little unclear actually to this day what the gateway to custody might be, but I know there are reported decisions where that test has been met under 39D. What is a violent offense again? So it's defined in the statute now. The most common one would be the young person causes bodily harm. The young person could also attempt or threaten to commit such an offense. And then there's subsection C, which was brought in around 2012. What if the young person's actions simply endanger the life or safety of another person by creating a substantial likelihood of causing bodily harm? I've seen very few cases that have relied upon that subsection. Some offenses will be obvious: a serious assault, a robbery, perhaps, obviously a sexual assault. Of course, bodily harm can include psychological harm. Those ones might at least theoretically be able to open the gateway. But again, don't just assume necessarily that the gateway is open. And if you're a Crown in particular, and you're taking the position that this offense, for whatever reason, calls out for custodial disposition, just be prepared to articulate to me or one of my peers why, and what's the legal avenue you have to getting there. It may be obvious, but it may not be. And again, if you're asked, well, which one of the gateways applies here, can you explain it? The blank stare is not going to come. So prepare yourself accordingly. And if your defense counsel, quite frankly, in pre-trials, I would encourage you to ask the Crown too. You please clarify respectfully, how you see my client stepping in and custody legally. Then you continue those negotiations. Okay, a couple more things, and I'm going to turn the slides off. It's one have more of a discussion, obviously. There are maximum sentences under the Youth Criminal Justice Act. So it is a 2-year custody and supervision order, even if the Crown proceeds by indictment. It only rises to a 3-year custody and supervision order if an adult is receiving a light sentence for the offense. Pre-sentence custody normally is considered. at least in this province, 1.5 to 1 does remain the standard practice for credit you would get. However, there is a case from our Court of Appeal called MW in 2017. And while it does require a youth court to, quote, take into account pre-sentence custody, you don't necessarily have to deduct it. And this can allow you to have some extra flexibility in youth court potentially. If you're concerned about the fact that while you may accept the judge is inclined to grant a custody and supervision order, and you're worried about butting up against that maximum, it is possible sometimes to impose near or at the maximum youth sentence. I suppose you might say on top of, or perhaps to a certain extent, not crediting the pre-sentence custody that already exists. The reason you might do that, of course, if your defense or advocate to avoid an adult sentence. Because if the 3-year maximum is deemed to be insufficient, that's half the test for getting an adult sentence in a case. But otherwise, even if the young person is resolving multiple offenses at the same time, even on multiple different charging documents or informations, that 3-year maximum applies. And I put the subsection on the screen for you there. So if you've got Johnny and he commits a robbery, at an LCBO, and he gets a release, and then he gets out, and then he commits another robbery somewhere else, and the Crown says, well, I'm in a bad mood, I want 3 years for robbery, that can't happen legally, okay? Because the maximum you're resolving all of these is a 3-year penalty for a youth. There are very, very rare circumstances where you can exceed that 3-year penalty and still receive a youth sentence. There's case law that's developed under that subsection. I don't want to dwell on today. It's a little more thick than what I wanted to get into, but it is out there. The exception being murder charges, of course, which have their own sentencing provisions. One other thing to keep in mind, there are no minimums in the Youth Criminal Justice Act. Okay, this is really important. There are still several offenses under the Adult Criminal Code where minimum penalties apply. And I understand that negotiations often start from that premise. Well, your client may be found guilty of a firearms-based offense or using an imitation firearm to commit an offense. There are still lawful minimums that apply, and this is sort of how we begin. Those don't apply in youth court. There's an older Court of Appeal case they put on there under the Young Offenders Act, which established that. But recently, Justice Cote, in a dissent in an adult decision called Hills, released earlier this year, noted as well that the mandatory minimum punishments in the code do not apply. She did write youth offenders. That wasn't me. Okay. But that was the language. The majority didn't comment on this issue at all. So the dissent isn't on this point, but it's right there from the Supreme Court, at least one judge. So
the no minimum sentences is important because it's not even, there's no minimum sentences in terms of the criminal code, but for youth, there's no minimum sentences within the act, if that makes sense. So there was a case that was, I believe it was a home invasion, where the judge issued a reprimand. And it went up to the Court of Appeal because the Crown said, no, this is way too low. And the Court of Appeal basically in one line said, no, a reprimand is a valid youth sentence, period. Because any youth sentence that is in the act is a valid sentence for any particular offense. So a reprimand can be valid if you can make it work for a firearm offense. So any sentence that's in the act is a valid sentence, if that makes sense.
the last thing.
Oh, yes.
Oh, I'm sorry. Go ahead.
I don't, because it's initials, so it's gone. But if you just do reprimand, Court of Appeal, I think it's probably the only case.
Okay, the last thing I'll say about this, choosing the level of custody. Again, remember, if you're the Crown on a file, you're going to advocate for a custody and supervision order. One of the questions my colleague should be asking is, well, what level of custody are you seeking here? Okay. Please be prepared to answer that. But if you're seeking secure custody, okay, there are certain criteria that have to be met. The default in law is open custody because the least restrictive form of disposition must be imposed. In this province, there's a case called LB, where the Court of Appeal helpfully explained this process. What the Youth Criminal Justice Act does, curiously, is it doesn't have its own section that lists the criteria for when a secure custody disposition is appropriate. Instead, it, by reference, points you to repealed sections of the Young Offenders Act, where those criteria are listed. So I put them on the slide to spare you the pain of having to do that. And it's in the LB decision. And I'm not aware of any province taking a different position on this. So of course, you will look at the seriousness of the offense, but also the needs and circumstances of the young person. We're not going to talk about that in a moment. Safety of other young persons in custody, hypothetically, the interests of society, that's kind of nebulous. And then of course, likelihood of escape if that's an issue. And any recommendations perhaps the provincial director might make. The point of this is just you're gonna have to justify for the Crown why secure custody is necessary. You can't just say, well, because, right? You need something better than that, because the default in law is open custody, assuming the judge even agrees the custody and supervision order is necessary. And I can tell you, like in Toronto, just very briefly, I don't want to make this all Toronto centric. We have a lot of open custody facilities, at least for boys in the city. And then you have the Roy McMurtry Center out in Brampton where secure custody is. Even then, sometimes for a family to have their child placed at the Roy, getting there and back to see your kid and have meaningful time with them is not so simple to do. When I speak to my peers who are judges in youth court across the country, they'll tell me sometimes the difference between an open and secure facility is like 3 hours between that person's community and where they're going to be housed. You're totally separating them from their family and their community. That would weigh very heavily on me, at least. I appreciate it may be necessary to meet the sentencing principles, but I would encourage you in your communities, wherever you practice, find out this information. Where is the local open custody facility? Where is secure? What's the difference? And what is the meaningful impact on my client and their family going to be as a result of one or the other? And absolutely, that is important to hear at the sentencing hearing. Yeah, even in Toronto, I definitely want to hear that. And I'm sure my peers. Sorry.
Okay, so, and also language is important, and I always talk about language, but it shows that you actually know the act.
Yes.
So young people are not convicted unless they are found guilty as an adult. So youth are not convicted, they are found guilty. Youth do not have criminal records unless they've been given an adult sentence. They have youth criminal record or youth court records. So youth court records, guilty findings or a finding of guilt. That's the language you should be using. You should not be using the terms conviction, criminal record. And in bail court, everyone says, oh, he has no criminal record. And if I'm feeling pretty snarky that day, I'll say, of course he does it, under 18. Yeah, but that's only when I'm feeling snarky, which is actually frequent.
I told you, came in the book, stop, right? Okay, so I'm gonna turn the slides off. There's more of the slides. I don't want to dwell on the slides. That's enough. I just wanted to use that to help orient us here and get us going. I should have said this earlier too. If you have questions and you're joining us online, please do put them in the chat and we'll do our best to incorporate. If you have questions live in the room, don't be afraid to put your hand up in that.
Or even live on the Zoom, you can also.
Oh, great. Sure.
Yeah, show your face. We want to see.
Yeah.
Yes.
I'm done. Go.
All right, well, so, of course, I will want to hear from you guys, but the main concern that we have right now, I think we're all pretty much aware of the fact that there's a rise in very serious violent crimes among youth, like lots of firearms and weapons at a younger age. Yeah, so I mean,
The Crown's telling you.
okay, so this is becoming a problem though. So, I mean, what can we do as defense lawyers, Emma, first of all?
Well, I think we have to be careful, right? Because we've been saying kids these days, I think forever, that kids these days are getting worse. The fact of the matter is that the crime or the offenses we're seeing in youth are a reflection of what we're seeing in adults. So we may see a rise in an increase in gun crime for youth, but we're seeing that parallel rise in adults. So it's not kids these days, it is what's happening around us these days. So we have to be really careful that we don't say, oh, these kids are horrible. It's not. We have a gun problem right now. Or actually compared to many places we don't, but it feels like we have a gun
But it
problem.
shouldn't be happening with the youth, so like that's the
But
issue.
it shouldn't be happening with the adults.
True, but I mean, adults, like, it's easier for them to have access to that, like it's.
See, I don't think it's all what we see and happening in youth crime is what we're seeing in crime that includes adults. So, and in terms of, like, I can speak to Toronto, if we're seeing a rise in gang affiliation for youth, it's because we have a problem with adult recruiting youth. So we're not seeing a problem with youth, we're seeing a problem with adults.
Okay, so I like that
Yeah.
point because what we're seeing also is these motor vehicle thefts where that we're just bombarded with these cases right now, and there are many adults who are using youths to do them, but it seems like the Crowns are punishing youths that they can get their hands on and not the adults. If the adults are the problems, why are the youths getting sentenced and punished?
Well, I think the adults are if they're being arrested. And in terms of the carjacking, and we are seeing more media reports on that, and I would argue, well, that's because that's the media flavor right now, because I have seen that in my practice throughout. And then when we saw the Maple Leaf guy got his carjacked, all of a sudden like that became the thing. We need to talk about carjacking. Carjacking has been an issue for some time. But, you know, if we're not targeting the adults, then that's a problem with policing. I would suggest that maybe we should be looking at that. And with certainly human trafficking, we're seeing that like we should be targeting the adult human traffickers as opposed to the youth victims that are recruiting their friends, but that's another tangent. But I'm very careful, or I urge or caution people to say, oh, youth these days, when it's not, I don't think it is specific to youth, but it's what's happening around us. And Erin, you've been saying, you want to say something.
It just wasn't clear to me when we started talking about the car thefts. If we were talking about carjackings in particular, or the Montreal-Toronto theft corridor. Because I see those things as a little bit separate. The corridor thefts.
Well, something that occurs to me is just this. You can't let general deterrence creep into youth proceedings through the. So if the Crown comes and says, look, we got a plague of car thefts coming around, you got to do something about this schmonner. My first question would be, are you suggesting I should apply general deterrence? And how I decide this case, because I cannot by law. That's simply completely inappropriate. And if it's simply a car theft, no matter how prevalent it is, that's not a violent offense. Right? So unless Johnny has got, 5 prior car thefts on his youth record, not criminal. There's no way. The maximum you're going to get from me is probation order, because in law, there's no way to get a if it's a robbery, that's different. Carjacking, that could be a violent offense, and the door might be open, obviously, right? So again, just this is the type of distinction or nuance that really matters to come into the meetings, not only with discussions between Crown and Defense Counsel, but when you come into a judicial pre-trial, that you understand, where you're coming from. And if you're the Crown, again, you can articulate how you believe, if you can, to get to a custody supervision order. But if you're defense and you think the Crown is wrong, don't be afraid to put your foot down and say, look, respectfully, I don't believe my friend is applying the statute properly in my position. You can't get there. So unless we want to have a trial where the only outcome at the end is going to be a probation order, maybe there's a better way to resolve this, given the emphasis on timely intervention in youth cases, right? Especially for first time, maybe even second time youth. You can get them into meaningful programming quickly between the offense and the consequence. That has really important value, right? As opposed to a trial. Like in this building in Toronto, I don't know what it's like in youth court. I haven't had a trial there yet, but it could be a year in the future, potentially, even for a youth. I don't know if it's that bad. Maybe it's not quite that bad.
A lot better now.
It's better now. Okay, let's hear it's better, but still, there's a consequence there. Just ask yourself, is the juice worth the squeeze, or maybe is there another way to get there?
So
we have a question.
Okay, so I want to hear from Dr. Skilling. So for people who are joining us who aren't, don't do youth work in Toronto, Dr. Skilling does the Section 34s for CAMH. She knows everything. She has a very huge wealth of knowledge, huge brain. She's the person I go to. After I get a 34, I often call her to do a debrief and have things explained to me. But she is phenomenal. So she's here, and I want to hear from her, because I learn every time I talk to her.
And sorry, and I just said this earlier, 34 means an assessment you can order under the Youth Criminal Justice Act. Typically, but not always, when you're concerned about a young person's violent behavior. And in Toronto, we send these requests or these orders down to CAMH, where Dr. Skilling and her team interview the young person and the family, and then give us back just amazing reports. So why don't you step us through that? If you see a case come to you and the young person has been found guilty, say, of a crime of some violence, what is your process and what are you aiming to achieve?
Okay, yeah. Before we do that, I do want to comment on the general deterrence. I mean, obviously, I appreciate it's not even part of the WiCCD. But from a psychological, research perspective, we know that if we want to change young people's behavior, general deterrence does not work. And the idea about specific deterrence, it really speaks to your point about timeliness. So if you want, there's any hope that that's going to be effective, it really has to be immediate and like very timely in a young person's life. And this goes back to Emma's earlier point about the time horizons for young people. And so, the brain is a developing organ, and throughout the course of adolescence. And one of the things that develops over time is the ability to be future oriented and to think through consequences and to be planful and mindful about, if I do this, then this will happen. And that really, that part of the brain that happens in the front part of our brain, which is the last part to develop. And so to go back to Emma's point about the grade 6 or 7, so if we're talking about a 12-year-old and sort of the capacity for that young person to be, thoughtful and reasoned and make good decisions that have a long timeline to them, is very different than if we're talking about an 18-year-old, but even talking about a 21-year-old, and to go back to the earlier conversation about brain development continuing into young adulthood. So, it's the case that that is happening for all young people. So all of the young people, all of you at some point, and me, the brain has developed over time. Hopefully we're all at the same endpoint now, but and then there's individual differences. So we have like the general brain development where you can say, okay, a 12-year-old is not a 16-year-old, it's not an 18-year-old, it's not a 22-year-old. But then we have the individuals, and I think that helps us bring in the idea of assessment and Section 34 assessments. And it's really about that youth. And so what is going on for this particular youth? And so I'm biased, obviously, since I do this work, I'm passionate about this work. I think it's so important to understand the specific, that person. It's really important to understand the person, not their charge, not what they did, but who they are and why are they here. And a Section 34 assessment is one way that we can accomplish that goal, is to really understand, why is this young person here? And importantly, of course, and this is what we stress to the young people that we see as part of our process, is that it's an opportunity for you to speak to the judge and to have your voice come through in this assessment. It's we want to hear why did this happen? We of course have our clinical expertise, and we will collect other information. We don't just talk to the young person. If you're getting a Section 34 report and all that's in it is a young person's voice, you should be concerned. You need to have other information as well if you want to get the whole picture. And when we think about young people, they don't exist. They don't exist in a vacuum. They're part of a family, they're part of a school, they're part of a community, they're part of society, right? So they're layers. They're layers, and you need to understand what's going on at all of those different layers that led to this specific incident. So, if we're talking about violence is multifaceted. That the causes of violence are multifaceted. It's possible you'll have a situation where you have a young person who's in the wrong place at the wrong time, and a behavior happens. It's completely out of the blue, and it's not, it's really unusual, and there's not a lot to know. That will be the extraordinarily rare case. Most of the youth that we're working with, they have complex, I think Donna already highlighted that, these complex backgrounds, developmental histories, they bring with them just so many challenges. And so having a good assessment is a way to be able to understand how those challenges come together to result in this current behavior. But importantly, so we can do a good assessment, and we can highlight for Crown attorneys, for defense counsel, for judges, here's how the person got to be here. But more importantly, some might argue, is what now? So what are we going to do next? And so you can understand, okay, this is how the young person got to be here, and what are we going to do now? And so what needs to happen? What's the plan?
On that note, I ask, how much should we involve the parents in the process?
Well, so ideally, caregivers are involved in the process. There are some challenges that we want to be able to identify. So, for example, attention and impulsivity and hyperactivity is a common set of symptoms that come in the youth that we see. And a diagnosis of attention deficit hyperactivity disorder might be relevant, which is a neurodevelopmental disorder. It impacts on a young person's ability to make reasoned decisions, especially in intense pressure situations, where there's a lot of peer pressure, a lot of stress, a lot of excitement. I don't mean in a good way necessarily, but in a high risk kind of situation. And so making a diagnosis like that can be really important because it can help us make a treatment plan for how to help a young person manage those kinds of symptoms. And that relies heavily on early developmental information. And so we need, if we want to fully understand some of these neurodevelopmental disorders, FASD, autism, whatever these kinds of early childhood disorders are, we need a developmental history, and parents are often the best providers of that history. Not always.
And sometimes parents are a huge part of the problem and why you're there in the first place.
Right.
So from my perspective, when I'm dealing with a client, parent involvement is directly how involved I get is what is totally 100% based on the instructions I get from my client. So if my client says, don't you dare talk to my parents, then I do not talk to my parents. I am not there to make better decisions or decisions I would like to make for my client. I take instructions from my client. If they say my parents are jerks, don't talk to them, then I will not talk to them. If parents call me and they say, what's happening with my son's case, and I have those instructions, I say, I'm not going to tell you. So I won't even say next court date. If I have those, and I get very clear instructions to my client, am I allowed to tell your mom when your next court date is? If the answer is no, then I don't. So it's a very clear line for me. We did have a question down here though.
I did about this report. I kind of have a two-part question. When you're ordering a Section 34 report, when do you think it's beneficial? So I've been asked sometimes by a justice whether or not like a psychiatric and a medical portion, but also an educational portion to it. And I'm wondering when you find that is helpful. And then I'm just finishing.
Yes, no, go ahead.
The other question I was going to ask is that we know that they're so involved, they're so incredible for us, but they also are very time consuming, and we know we can't order them on all of our cases. So I'm wondering if any of the three can help us understand and the criteria, of course, for Section 34 are outlined in the provision, but when it might be better for us to think about a PSR under Section 48.1 versus the Section 34 report.
So in terms of, I was actually spoken about last week in the conference in terms of when to order these assessments. And it's a fine line because yes, they offer valuable information. Yes, they can be very helpful, but at the same time, this is a criminal justice system. We are not here to parent or to help youth. That's not the purpose of the act to say, oh, we have this kid, let's see what we can find out. That is not the job. So it's a very fine line because what I'm sometimes concerned about is that we have what would be considered not very serious offenses, and we're ordering these reports. We're getting very involved when the disposition is like, oh, maybe we're both going to agree on a peace bond at the end of the day. I'm concerned about re-traumatizing youth because these reports can be very invasive, and we don't, for something that you know is going to be dealt with through an alternative measure. Is it worth re-traumatizing this child, getting really into this, and then for what purpose? Because this, with the cognitive and academic assessments, we can have those released to any academic institution in the future. With the Section 34 proper, there are a lot of really restrictions on it. So we can get this really, invasive report where we get a lot of information and then the charges are withdrawn. So why did we do that? Why did we get this report when it's just like, oh, you did the report, thanks. Okay, we're going to withdraw the charge. Then it's like, why are we doing this? So there has to be the question of why are we getting this report? Depending on what comes out of it, what is the purpose? What are we going to do with this? Certainly there are cases like absolutely 100% you should be asking for these assessments. But if it's just like, oh, I'll be happy if they do it, an anger management course, this is being withdrawn. Let's just get an assessment just to see if anything else is in there. Like, no, we shouldn't be doing that. That's not what the act is there for. So it's just, yes, they're helpful. They're also very invasive. yes, they give us a lot of information, but why do we need that information? So it's one of those, I think it's a tightrope that we're walking, and sometimes I look back at some of the cases where I asked for a 34 and I think, oh, I shouldn't have asked for one, because we were invasive for no reason. So just, I think it's a fine line, and I worry that because we're dealing with young people, that we all have that urge, like, oh, we really want to help this kid out, we really want, but that's not, we're not there to parent, we're there to navigate the criminal system. So I don't have an answer for you. These are things that you should be thinking about, though. So Aaron, you had something, and Dr. Skilling. So many people have things to say.
Go ahead.
Yes.
Yeah, I think I love listening to this, and I feel sort of single-handedly responsible for the current backlog of section 34 down here.
We had a ordering spree, but we're catching it.
Yeah, and when I look back at all the ones I ordered, there's only one where I think, perhaps it wasn't necessary, but that was only after I read it. And it was not as bad as I thought it was going to be, although I did think that I was astonished that there was not a finding of there was no diagnosis of a complex developmental trauma. The kid had been in and out of CAS for more than 10 years. So I thought that really shocked me. But when we're talking about, the criminal justice system is not here to help children, I disagree with that. I think that's what the rehabilitative and reintegrative portions of the WiCCD are actually talking about in, terms that are more legally acceptable. And we can't come to a just sanction unless you have some idea of what are the rehabilitative needs of this young person and how am I going to find them out. And in the Crown pretrial, what often happens is, the defense lawyer will start telling me, oh my gosh, yes, he did put the boots to this kid and like pound the living crap out of him, and it's all captured on video and posted to social media. And, yeah, we're lucky that he didn't break his neck, etc. But, he's got ADHD, he's got already a diagnosis of both anxiety and clinical depression. He's got like multiple things happening. And so I think, like, am I just gonna go, oh, okay, let's just put him on a probation? The other thing, and I will admit this, like, I think a lot of families would not be able to afford this type of information about their child who's experiencing a great deal of trouble and trauma. And maybe those things that make them especially vulnerable to the predations of adult offenders trying to suck them into different types of things. And I mean, I just think they're the bee's knees in the legal forensic sense, right? That we don't have anything like it for adult offenders unless you are in really specific circumstances. I just love them, and I apologize in advance for how many more I'm going to order.
And I don't mean like we shouldn't be there to help the people that they use that, of course, no. But it's not like if you get a case, it's like, oh, this is a stupid theft under. Oh, but while they're here, let's see if there's anything else going on. Like, no, of course, like exactly, you get the yuckies right there, and you should. So that's what I mean, where it's just like, oh, we have these youth, we can get them to do what we want. So let's just see if there's anything else going on. Like, it shouldn't be used as a fact-finding process. Of course, if you have a young person that's like, dealing, has firearms issues, is, violence, of course you want to see, okay, what are the mental health issues that may be contributing to it. But if you have a young person that's there, that's like, where at the end of the day, I don't, just make this go away. This is not worth my time. What I'm saying is, okay, we shouldn't be saying, okay, let's dig and just like see if there's anything else that that's what I'm talking about. So of course we should be helping the youth, but not like, oh, every youth that comes, here's our opportunity to see what's going on. So just, that's the line I'm talking about.
I think my question is more though, when you got that intersection, maybe it's a violent offense and there is a lot going on, but there's still going to be a time, I think, when a 34 is appropriate and when a simple PSR may be better. I'm struggling with that with a lot of the reports I have from your perspective.
Yeah, so, and it partly depends on your jurisdiction. So we are the jurisdiction, CAMH, we do assessments for the Toronto and Newmarket courts. And we have a way that we practice. So I'll just say, we're talking to people who don't all live in Toronto. And so your service provider in your various jurisdictions may or may not. I'm speaking on my personal, like, there's no like this is a section 34 and this is what happens, that there's not actually a standard sort of process around so I'm telling you what I think, just so we're clear. And so I think PSRs there's a lot of overlap with the section 34s in certain aspects. So for example, in your PSR, you will get some family background information. You'll get information about school. So here's one good way that they differ. So you'll get information about school. And if there is a previous learning disability diagnosis or a previous educational need that's in the student's record, the PSR will know that, like the person will know that, and they can also highlight that in their PSR. But if there's not, or maybe that was done when they were in grade 3, like often the psychoeducational assessments, if they have been done, they're often done around grade 3 or grade 4. And now we're working with 17-year-old youth, right? And so a lot can change over that period. And so one of the things that you can have as part of the section 34 is an educational or learning assessment. So we can get, a better understanding about academic challenges. And I bring that up because the rates of academic challenges in the young people that we're working with are astounding. And so as part of our work at the CAMH, we did a follow-up study of the young people that we saw for assessment, and we looked at their educational outcomes. And we followed several hundred youth for several years, which would have allowed them to finish high school during that period of the follow-up. And only 25% of them, maybe 27%, about a quarter, actually graduated from high school. And so if you look at any Ontario stats for any even subgroups of young people, that rate of graduation is so much lower than any other group of youth that you'll encounter as kind of an average. So when we think about what are the potential outcomes of that, like you're getting youth that are not graduating, they don't have an education. Many of them are reading at the elementary school level. Those kinds of challenges are going to impact them down the road. And I hear Emma, absolutely. I do. I can be loud and clear. And I get it. The youth justice system is not the child welfare system. It's not the social services system.
There's a chapter on that here.
I know there is. And this is an opportunity to have an impact on a young person's trajectory in some ways. And so again, of course, it can't be abused, and resources are limited, and not everybody is going to get a comprehensive I won't use the word intrusive assessment, but a detailed, comprehensive assessment around all aspects of their lives. It won't be needed for every young person, but there are ways that it can be different than a PSR. So that's one. So educational, cognitive is the other thing. So a cognitive assessment, again, I'll highlight for the group that the rates of cognitive challenges in youth who are justice system involved are extraordinary compared to the general population of youth. And so in the general population, if you look at estimates for intellectual disabilities, about 2% of young people in the general population will have an intellectual disability. The rate is about 4 to 5 times higher in youth. Yeah, youth who are justice system involved youth. So so the rates of like actual intellectual disability where you would get a diagnosis, you will be eligible for lifelong supports, about 5 times higher. And then the rates of, they don't quite meet this diagnostic criteria for an intellectual disability, but their cognitive functioning is what we call in the psychology realm borderline. Which means that they're still far below the level you would expect for a young person their age. About a third of the young people that we see in our clinic, so we do cognitive testing quite routinely, about a third of them will fall in that range. And so it means that they are functioning. Again, so when you think about, so you have the 17-year-old before you, but that's not, and again, we think about general brain development. you know, they're not an adult yet, they're 17-year-old, but they're getting there. Unless they have an intellectual disability or a significant intellectual challenge, and they're actually functioning like a 10-year-old from a cognitive perspective. So they look like a young adult, but that's not how they're thinking, right? And that's not how they're making decisions. And so for me, that's one of the, it's a challenge though, because it goes to your point about, well, how would you know that you need to have that kind of assessment? And so I do think issues like school, so are they in school? How far behind are they? So I said, so about a quarter of the young people in our follow-up study actually graduated from high school. And on average, I think the average number of credits was about 7. So you need 30 to graduate. So it's not even like they're almost there. So they just decided to, oh, you know, I pretty much finished school. I'll just go do something else. No, they're not functioning at the level that you would expect for their age. And so it's such an important thing to understand, like their decision making, their problem solving. Yeah.
But to answer your question, so, and it's not like I know what the answer is, because I struggle with it, right? Because I see that these assessments are useful. And then, but then I worry, but then I also see cases where we get the assessments and then nothing's done with the assessments because it's just like the charge was so minor, nobody really cared. So, and then I'm like, well, why did we do this? You know, so I don't know the answer. When you're struggling, you should be like, it's asking counsel, how are they doing in school? What are it's like? What is going on at home? You know, who is at home? Where do they live? Because as soon as you know certain neighborhoods, you know what the exposure to violence likely is. And look to the act, because the act says this is when you should be ordering one, or it gives you some guidelines in terms of when it should be you should be ordering it. But also, what do you want at the end? Is this because you're trying to decide whether or not to ask for custodial sentence or a discharge? Then yeah, that could be helpful. Or is this just like, yeah, I'm just curious about this kid, what's going on, so it's like, what is your motivation in asking for? What are you trying to get? What are you trying to decide? What's the information that you have? Do you have reason to believe that there's a mental health issue that led to the alleged offense? Like, just start asking those questions. I don't know what the answer is. And, when I say I'm struggling with it, it's because I am struggling with it. I am waking up in the middle of the night thinking, what am I doing exactly? When I'm asking for these assessments and then, and
When
then
you're a judge.
and then they're sealed, like, because section 34s are so tightly controlled. So it's not like the youth owns the report, the court owns the report. So why am I asking for this report if the youth doesn't even have ownership of it? So I am struggling. I struggle with, I don't know what the answers are. It's just something I struggle with it. So
On that point,
Yeah.
I want to add something. That's very important in this last comment there. Not just the court, but the Crown's office obviously will retain a copy of this report lawfully, mind you, for the disposition of the case for which it was ordered. My view, be cautious if you're in the Crown's office and you have access to a 34 report. Now you're onto a new case involving that same young person. Do not assume that you can or should or may lawfully access the 34 assessment in an older case for future purposes, especially, like neon stop sign here, okay? When the access period has closed for that old youth file. There's a reported decision from the Ontario Superior Court involving an adult. The case is called Robertson. So it's really shameless. It is actually in the book. We put a whole section in about this, where the Crown ordered a dangerous offender assessment, okay, for this man as an adult. And they just got the old 34 assessments that turned out existed somehow from the ministry responsible for children and youth. And they just provided it to the assessor under the Adult Criminal Code Dangerous Offender Assessment provisions without any court order whatsoever. And when defense counsel noticed this, challenged the Superior Court, the Crown's argument at the Superior Court judge was pretty much humana, whatever, we had it. This did not go over well with the Superior Court judge, who ruled that it had been unlawfully accessed and effectively ruled the assessment report that was based on it inadmissible as a result, and then ordered a new assessment report. You can imagine what time it takes to do any dangerous offender proceeding, right? Now the time is just ratcheting up because the Crown allegedly found by the Superior Court judge to have violated the privacy rights of that young person. By just assuming we just will get the things we got once before. We're the state. we just have it in our giant vast, vault of information where you crowns go with your keys and keep everything locked up, right? You can't do that. The records provisions of the statute are beyond the scope of this presentation, but be very cautious about that kind of thing. Just because you get access to this highly private and sensitive information for one file, it's not mean you have access to it necessarily for all future purposes forever and ever, which I'm sure is something that you would talk to your client about as a concern, right? That the government, so to speak, now has this.
Yeah, and that is my concern when I'm getting a 34 too, is I'm back, when I'm giving these assessments that are very detailed, go very much into the youth history. And let's say their guilty finding rolls over into an adult conviction and actually becomes a conviction, again, beyond the scope of this presentation. But if their youth guilty finding becomes a conviction, and let's say there is an application to access that 34, and yes, let's say that section 34 is used in the future DO application, and that section 34 wasn't necessary on my end to get the disposition I wanted. Like, I don't know the answer, but these are the things that I wrestle with when I'm asking for a section 34 is, yes, I'm helping right now, but my job is to protect the youth in the future as well and to be forward thinking. So these are also things that I think about and keep me up at night. I don't know what the answer is. I'm just saying it's like, these are questions we have to ask ourselves when we're working with youth, because I worry all the time that what I'm doing in youth court is in thinking that I'm helping the young person is setting them up for a lengthy penitentiary system as an adult, where maybe they wouldn't have that if I wasn't involved. Like, these are all the, like, these are the things. I'm up a lot at night. I worry a lot. I think so. I don't know what the answer is.
But I wanted to ask you a question because, we want to try as lawyers to get them to rehabilitate or reintegrate, but some of them, I'm sure you've had clients, Emma, who have zero interest, whether it's academic or work. They really don't. They're not interested in working, and that's maybe why they navigate towards crime. It's because it's fun for them. But what do you do with these types of kids who really they don't want to go to school?
I take instructions, right? And a young person that really is not interested in anything is actually,
I want to give him a tip.
what was that? Is actually, I don't know.
I'll give you the money I'll get.
But I gave you all my dollars.
So
you paid with the cash?
Yeah,
Can you mute yourself if you're not?
No, we muted. So
it is a concern for me, or it is a concern for me when a young person is completely disinterested, because that is usually an indication of something else. But ultimately, my job is not to impose what I think is best for the young person. I take instructions. And if they say, Emma, I don't care, do this, then I'll go and say that. And then, because I take instructions, and lawyers have to be really careful. Again, about walking that line. We're not there to parent or make better decisions for the young person. We're there to take instructions. So I take instructions.
I think something else to be pointed out is this: if you're before me on a youth case, I'm sentencing Johnny or Susie for the offense, right? If it turns out that they don't go to school, they have no interest in going to school, I'm not there to sentence them for that. That's not what youth criminal court is about. Obviously, it may speak to their rehabilitative prospects, at least in the short term. They seem to lack the foresight to appreciate going to school actually matters. I'd have a discussion and I try, but I'm not there to quote punish them for something like that. That's when I've gone totally outside what my jurisdiction actually is as a youth court judge. So is there some role for that evidence? Of course, it's relevant background information, but we shouldn't be putting terms on these orders or otherwise imposing dispositions that aren't connected to what we're there for, which is the criminal offense, right? I appreciate the point you're trying to make, though, Maya. Someone, idle hands in the devil's playground, so to speak, right? And if they're not in school or otherwise engaged, they're going to be more easily led astray. That's something to consider, but at the same time, we can't allow inappropriate things to result from those genuine concerns. Criminal court, again, has a certain limit to.
I think that's a good example, though, of, the idea, because an assessment, I'll argue, an assessment can be really helpful, right? Because maybe there's an undiagnosed learning disability. Maybe there's other mental health issues that are, maybe the young person is depressed and they can't get out of, they don't want to get out of bed and they don't want to do things because there's an underlying mental health issue, not because they don't want to, really, right? So at the same time, yeah, is that the reason to order the section 34 assessment? Again, thankfully, I don't have to make the decision about whether they get.
Thanks a lot.
Or an ag assault as opposed to a theft, right? Like,
Yeah.
you really, and again, the YCJA is not there to parent. So, and that is something I have to keep telling myself all the time.
We have a question in the chat, actually. I just want to talk about this briefly. So the question is, when a young person, I said you committed your offense when you were a young person, but now you're chronologically 20 plus before you're sentenced, still in youth court technically. Okay, if you're sentenced to custody, you must be actually normally sent to a provincial facility for adults, right? So regardless of whether the judge says secure custody or open custody, the reality is that means you're stepping into an adult facility. And then the question is, there does seem to be a provision that allows the provincial director to order otherwise. So it might be possible to have that sentence served in a youth facility, even though you're now chronologically 20 plus. I can't speak for the provincial director. I don't know when the provincial director would ever consider that. Have you ever had that happen?
I've argued, that's why I've argued for no custody, is because in the act, and I forget the section, it is shall, the provincial, it is very presumptive. The provincial director shall put the young person into an adult facility if they're over 20. So that's why I argued to keep a young person who is now an adult to order a non-custodial disposition, because the presumption is they shall. And the fact of that matter is that short of a sentence review, that the decision of the provincial director doesn't go to the court, and the judges aren't involved and the court's not involved. It is a very presumptive provision. So what was the question?
No, I don't have jurisdiction, and you have to understand why this is. If you're chronologically in 20 plus, you are. And there are going to be young people in that facility. If, God forbid, my 14-year-old son got into trouble and found himself at the Roy, that's depressing enough. The idea that his bunkmate might be 20, that's really depressing. Okay.
We're thinking of a decision when we're saying that. Justice Cohen's decision in AA, where, so Justice Cohen did his beautiful decision, where she held that ankle monitoring violated the YCJA because it identifies the young person as being dealt with under the act, and also it doesn't accord with the record provisions. Wonderful decision, but one of the things that she also discussed was that how the Roy has now turned into the Roy, which is the youth facility in Toronto, that's in Brampton, but how that has effectively become an adult institution and a young adult institution, and there aren't actually youth there, but there are 18-year-olds and 19-year-olds. And if you look at the numbers at the Roy, it is a young adult facility. And so the danger of having a 13 or 14-year-old detained going to the Roy, and then that now is their peer group, is a bunch of 18 and 19-year-olds, and the dangers that can result from that. So anyways, RVAA, it's on Canley, I hear. Justice Cohen, beautiful decision. She's a wonderful writer. Read that.
But I don't mean to hijack your presentation, Mike, but
That's what we did.
like that level of submission though would be really impressive to me, because if Emma comes, somebody comes before me and they say, but the reality is, Your Honor, if you accede to the Crown's request, my 14-year-old client is going to find himself at this facility most likely. And the people he's going to be surrounded by are home, because I've obtained this information either from the provincial director, or maybe it's noted in some recent decisions or whatever. Like that speaks to the reality of what it means stepping into this custodial facility for this young person who's actually 13 or 14 or 15 before me. And in other jurisdictions around the country, I'm sure you could find out this information about where you're going to have your client sent if this actually happens, right? I think it's in the Hills from the Supreme Court, also released this year for adults. They talk about how sentencing courts must consider the cold reality of what it will be like for an inmate to be in certain institutions based on their particular vulnerabilities. So this is the kind of thing that, if you dig deep and you get this information, especially as defense counsel, if you can really have a powerful argument about what does this mean in practice. It's not just some, ethereal concept of custody.
I have something to say.
Yes.
And another thing, if you're defense, one of the things you should absolutely be asking your client if they are in custody, if they're either in secure or open, tell me about your strip searches. So when you're in secure custody, how many times, tell me if you're strip searched, tell me when you're strip searched, tell me how many times it's you're strip searched. If you're in open, Are you strip searched? Are you strip searched when you come to court? I want to know all about your strip searching history, because that, I think it would shock you. And that could also help you in submissions, to a judge in terms of asking for certain sentences. So you should be asking those questions. Tell me about the strip searches. Tell me exactly what's happening in your day to day. Because I think the answers may, shock, you as a defense lawyer.
And there's one other thing, sorry, then I'll,
Because we're talking about young people, right? We're talking about strip searches with young people.
sorry, one thing, and I'd be remiss if I didn't mention this. Statistics Canada puts out information regularly about the youth criminal justice system. So for the 2020-2021 statistics, I put this in the slideshow near the end. Indigenous youth across this country continue to represent about 1/2 of all youth admissions to custody, while they represent about 8% of the youth population. Now, these are just staggering numbers, right? And the Offenders Act was repealed primarily for exactly this kind of problem. The problem remains, the numbers are down in absolute terms, that's the good news. But this is still something that's going on. And it's also a problem for other vulnerable groups of youth. So again, if you are in any community, of course, the new principles always apply, but if you're in a community somewhere in this country where this is a particularly acute concern, again, I think this is just so important to have this kind of information there. And I would hope my peers would at least take judicial notice of what Statistics Canada puts out. But in addition, anything perhaps more local and specific, this has got to be something that weighs on judges, I hope, when they make these decisions. Sorry.
Yeah, what were we talking about?
We'll get back.
Can I jump in though?
Yeah.
Because I want to add something about the custodial piece too. One of the reasons, to go back to the earlier question about the difference, or what's the difference between a PSR and a Section 34. The other, so there's a piece I think that's really important around cognitive and academic assessments. The other piece, of course, is mental health. And one of the things I want to highlight, especially we're seeing this a lot right now for our youth who, so they're not serving a custodial sentence, because of course I'm doing these assessments pre-sentence as well. And so they're in detention, but sometimes for long periods of time. And when they enter detention, many of the youth that we're seeing have serious substance abuse problems. And so going through withdrawal while you're in a detention facility, most of the youth that we speak to, they don't share that information with the adults who are supervising. And so they're going through withdrawal symptoms. Some of those kinds of symptoms are particularly impactful around being easily irritated and annoyed and not feeling well and kind of being grumpy. So right, like there are those kinds of symptoms can obviously impact a youth's behavior while they're in detention. And the other thing is trauma. And so a significant proportion of the young people that we see have very significant trauma histories. Again, to go back to general statistics, very few young people in the general community meet criteria for PTSD. It's very low, thankfully. But in the youth justice population, of course, it's not surprisingly much higher, many times higher number of youth who meet criteria for PTSD or other kinds of complex trauma. And again, some of those symptoms are things like being hypervigilant to threat, being easily annoyed, being moody and emotionally dysregulated, nightmares, sleep troubles. All of these kinds of things will impact, obviously it impacts their behavior in the community. It will also impact their behavior while they're in detention. And it's really important to think about that. I think in the context of a young person going into a secure setting where the resources available to provide intensive psychotherapeutic supports are potentially limited. So that's another thing to think about. Again, how do you know that your client has PTSD, prior to getting an assessment? But again, if you're, Emma's saying, talk to your client, like, I don't know how forthcoming they'll be, but maybe if they're telling you that substance use was a serious concern, that might be something for, to kind of trigger that alert, like, oh, well, this could be a challenge if they're going to be in a detention facility.
And then all this, the sister diagnoses of trauma, are, you know, the ADHD, ADD, opposition defiance, all those diagnoses that come. So all the ones that would make it very hard for a young person to sit in school from 9 to 3:30 may be as a result of trauma. So trauma is a tricky one because you know, trauma can impact not just, you know, day-to-day functioning, but even just the ability to concentrate in school. So if a client says to me, I really can't pay attention in school, or, you know, you know, I've had clients who they're in my office and they can't stop moving. You know, I've referred clients to assessments just because of how they present to me in their office. Like if they can't, if they're, you know, if they just can't sit still during the regular conversation, you know, so defense lawyers you have to dig deep, you have to do the work, you have to interview your client, you have to get to know your client. And then, you know, if you should be asking for a section 30, or you should have a better idea of whether or not a section 34 could be helpful.
What if they tell you that judge is so boring? They do then.
Well, they always say that, and so this is. And so it's funny because, you know, when they, and this is another thing is that, you know, how youth present in court, because, you know, one of the things that, you know, we have judges now that aren't specializing in youth cases, but when youth appear uninterested in court, it's very rarely because they're not interested. It's because they don't know how to act and they don't know, you know, and if they're nervous, they may start smiling or laughing and all those things that we interpret as adults as being disrespectful. But that is just because they have, you know, who knows, they don't know what to do. And so I hope that
they don't know what's going on.
They don't know what's going on. They don't understand.
Language, the vocabulary.
Yeah.
The content is difficult and abstract.
Yeah, so just be, you know, I would say, and I, you know, for judges that are, no judges are blowing up the one, but judges that, you know, or even if you're a crown and a youth is acting inappropriately, to not say, oh, you know, look, you know, this kid doesn't even care what's happening. It could very well be that the youth doesn't know how to act, that how they're acting is a trauma response, or how they're reacting is a trauma response. And it just, you know, to not highlight that in court, because you have no idea why youth are acting in court the way they are and what that is coming from. There you go. So where are we? What time is it?
Well, we have a few minutes left. If anyone online or any questions.
While we wait for a
I
question,
do have.
you do, go for it.
Okay.
Honey Kelly?
Shauna Pemberton.
Hi. Oh, good evening, everyone. I just wanted to, well, thank you for putting on this presentation. It's a topic that's near and dear to my heart. It's lovely to see you, Emma. I wanted to just highlight that I think it's important as defense counsel that we are cognizant and aware of whether or not our clients are in the child welfare system. So if they are connected with the Children's Aid Society, I find that it's very helpful to be collaborative with, you know, with that partner. I view them as a partner and try to get as much information from them as possible, because there are, you know, a wealth of resources that the Children's Aid Society can offer our clients. For those of you on the call that do work with the Office of the Children's Lawyer, you know, it's important, I think, as defense counsel that we are aware of whether or not our clients have that type of connection. And, you know, if they are eligible for resources like a visa, these are important things for us to consider and contemplate when, as you say, Emma, we, you know, dig deep and find out what the background is with respect to our clients. So just throwing that out there, because we didn't really have a chance to touch on child welfare issues, but I do think that that's an important subject matter that we shouldn't neglect.
So one of the things I'm trying to start a movement on, and it's been totally unsuccessful, is the CYFSA, the child, this is in Ontario for people in I don't know the legislation in other provinces, but the CYFSA, which is the child welfare legislation, has a very strict, it's, I think it's section 88 under the CYFSA, where you are not allowed to identify anybody who has been dealt with or is subject to a child protection proceeding, or a foster parent, or anybody that, I forget the wording.
Or
witness. A witness. Yeah, so my concern is when we go into bail court, especially when we're representing 18-year-olds or 19-year-olds or 20-year-olds, and say, you know, this, my client was in care, and you're saying that on the record in open court. My concern is whether or not you are violating the CYFSA publication ban, or not. It's not even a publication ban, it's identifying the young person or the child in the CYFSA context. So one of the things I've been kind of urging people to consider is whether or not we should be asking for a publication ban when we're talking about child welfare status. We should be asking for a CYFSA publication ban as well, because there is the WiCCD publication ban, but you can have dueling protections. And so especially if records, if a record which would include a transcript potentially rolls over to an adult conviction, are you violating the CYFSA? So I've been totally unsuccessful. I've been saying this for a couple of years now. It's not happening, but for those that do have clients in the child welfare system, to kind of think about that. Am I violating the protection and the publication protections in that legislation?
And can I just make one other observation? About half of the youth, and we talked about this earlier, who come into contact with the youth criminal justice system, have past or ongoing involvement with the child welfare system. What does that mean, right? If a youth has been found, child, to be in the need of care, it means that a judge in family court has found that they were the victim, right, of abuse or neglect or abandonment, right? I think that's the starting point. And they have to navigate that whole world on a regular basis. Then they come into contact with the youth criminal justice system. Now they're in two different court systems, different lawyers, different judges, sometimes different jurisdictions. And if they're in a group home, often the group homes just shuffle them around. Something goes wrong, or God forbid, any charges added, like a breach or anything even minor. This just becomes extraordinarily difficult for anyone to handle. I mean, imagine anyone in your life having to go to court, multiple courts, all the time to deal with ongoing issues they have very little control over whatsoever. None of which is necessarily excuse what may have brought them into criminal court, depending on what it is. But I would ask you to keep in mind, especially if you're a Crown and you're reviewing these files, you know, the very tragic and quite frankly, often emotionally difficult experiences that these youth have been through, why they find themselves in that family court world to begin with, and perhaps how it can be assessed in terms of how to deal with them in youth criminal court. Right? Now, it's not like they're the proverbial kid who just grew up in some nice suburb somewhere and decided to go commit a crime or steal because they're just, you know, a little brat. Right? It's way more than that. And I think viewing it that way is just essential to coming up with an appropriate disposition often. And I know Justice Scully, now retired, my board, would often talk about the importance of appreciating, you know, a trauma-informed perspective on how these youth have come involved, both with the family system and then also obviously the youth criminal system.
And then drawing from that, as if for the Crowns that are listening, and I say this a lot, is that to be cautious of when you are in defense counsel to everybody, when you're to be cautious when you're making submissions, that a young person is there who has often lived through horrible experiences, and to be very cautious about what you're saying in the open court and whether or not you are traumatizing that young person by your submissions. So I would urge all counsel, that if you do have a mental health assessment, instead of talking about, you know, sexual abuse or physical violence, to say, you know, for example, paragraph 2 on page 34 of the assessment, you can see that there were family issues, period, and just leave it at that. There's no reason when you have a written document you can't just reference the document as opposed to actually referencing what happened, especially when you're dealing with joint positions, because what happens in court can be very harmful. So just to be mindful of that as well.
One of the things I'm hoping we can just touch on as we're running out of time is to go back to an earlier point about how these reports get used, like a section 34 assessment, and whether they get used down the road. But also just thinking about rehabilitation and treatment. So if we have young people, violence is the issue, we've come up, you know, you've had an assessment, there's a treatment plan articulated in that assessment, and then what happens next? And so, you know, where the reports go and how they're used is such an important point, because we really have an implementation gap. So we actually know quite well from decades of research, actually, that we know the kinds of challenges that are going to come up and that need to be addressed. And we have good treatment programs. Not, you know, there's room for improvement. There's lots of things we need to continue to work on and improve. And we can have success. And so, but we can only do that if something actually happens with the assessment. And so we've identified these concerns. We understand why this young person, in the context of their violent offense, how they got to be there. And we've put together a plan to help with rehabilitation and reintegration. And then it doesn't go anywhere. And or even if it does, it's not executed. So one of the things that you'll see in the research and in psychology, we talk about an implementation gap. And that is where we know what the issues are, we know how to address them, but nothing happens. And so we have research in our Toronto context. We followed youth after they finished their Section 34 assessments through their probation terms over a 3-year period, and we've looked at what happens. And on average, in one of our CAMH assessments, on average, there's usually about 5 needs kind of articulated on average. And what we found when we followed through to the end of probation was on average about 1 of those needs are met. And so when we talk about, when we say like, this isn't working, or this young person is reoffending and they're in trouble again, you know, did anything actually happen to change, right? So it's not enough to say, okay, we understand the challenges. We actually have to help. We have to do something next.
That definitely happened at the pandemic for the young people that were sentenced like 2 weeks before lockdown. And then, you know, got rearrested in September or whatever. And it was just like, well, we just got this assessment. It's like nothing happened, you know. So I really saw what you were talking about happen during the pandemic, because we were not equipped for the lockdown, and we lost a lot of youth there because they're just the supports they already had went away. School went away, and school for some of them was a lifeline. So the pandemic affected youth in a way that we're going to be seeing for years and years.
Well, that's true, but we're out of time.
We are, so thank you very much for this excellent presentation and discussion on youth criminal justice, and we will be giving a prize. So I'll let you guys decide. I'll tell you about a temporary problem.
Okay.
Okay, so what's story is that Mr. Mitchell and I had a temporary problem maybe 15 years ago. It was a while ago. And basically everything I just said, yeah, but he was so high. He was so high. And then you say, but then he did this, and then he officer.
No, just walking like naked in the street and like threatening people.
He was so high. He was so high. And then everything that he asked us, and I just don't think you understand how he was so high. And so basically, I mean, he just said, okay, forget it. Just do this, go away. Never call me again. So anyway. Each other, we just go so
Persuasive submission I've heard. Quite a while.
and he didn't matter. It's like, but Emma, but then he went and like stabbed his person. Yeah, but he was so high.
Right, if you're online and you heard all that, we gotta go. Thank you so much for coming.
Yes. Question, Shauna?
I just wanted to ask, is there a section in the book around sexual offenses with respect to youthful clients, or no?
It's not like an entire chapter or anything quite that detailed, but we do talk in the sentence provisions a bit about
Okay.
some of what you might be alluding to. But
Okay.
I don't want to, you know, tell you to buy the book under Yeah.
Dan Brown's sexual assault book is coming out with a 3rd edition shortly, and so that's why I said I don't remember, because Dan Brown's book I've read a lot, and so I kind of, I get mixed up. But Dan Brown is coming out with the 3rd edition of his really wonderful book.
Great. Okay, thanks.
Thank you very much.
Thank you.
Thank you.